Welcome to this show. This one will cover the arrest of the clerk in Kentucky and the law. It would appear the country has come to an impasse. If I get what I want, the Constitution doesn't apply. First, let's look at the part of the Constitution the Supreme Court violated. What did they violate? The separation of powers. As set forth by the United States Constitution, branches of government have been held separate from each other so as to ensure that no one branch may overtake the others in pursuit of some abuse of overall power. The government branches that fall under this separation of powers include the executive, legislative, and the judicial sectors. These branches of government each have prescribed levels of power as set forth by the Constitution. In relation to the executive domain of these government branches, though presidents are granted power to oversee command of military forces as well as the ability to ensure that laws are passed as well as treaties set forth, they do not actually possess absolute power. When referencing the military, the president may place those duties onto other individuals who may devote all their time to such endeavors as the military interests. In addition, Congress may dispute any presidential decisions. Therefore, the president, though possessing certain powers, must actually also adhere to the direction set forth by Congress, which may override decisions made by the commander-in-chief. I wish someone had told Obama this years ago. The category of government branches that Congress resides within is that of the legislative branch. The legislative power is totally within the realm of Congress, as Congress assumes exclusive authority in terms of legislation. It may not, under any circumstances, delegate its powers to any other branch of government. Yet, the EPA can pass regulations that people believe are laws. Hey, EPA, fuck you! This was reiterated in Clinton v. City of New York, where the Supreme Court stated that Congress is not permitted to delegate a line item to the country's president. According to such power, Congress attempted to delegate. The president would have the authority to abolish provisions of a bill prior to inputting his signature upon it. The third member of these branches of government, the judicial branch, maintains that the Supreme Court, as well as other smaller state and district courts, possess the authority over cases brought forth for decision to the court system. The justices of the Supreme Court are appointed by the President with the support of the Senate. And now we understand why we have the fucking retards we have in the Supreme Court. Upon appointment as a Supreme Court Justice, you will remain in that position for as long as you may physically and mentally be able to. The key point here is mentally. In order to ensure the prevention of such abuse of powers by these branches of government, a system of checks and balances exists. Well, they used to, but they don't really anymore. This system allows each branch the power to limit the others, thus allowing self-regulation among the three branches of government. The legislative branch may compose and enact laws, while the executive branch may veto laws. Hasn't happened in 7 years. The judicial branch has the power to provide determination as to whether or not a law is unconstitutional. Not lately. Lately they've been writing fucking laws. It is a constant checking and rechecking of the acts of each branch that occurs. One criticism of the separation of powers in terms of branches of government include that it may lead to a less efficient governing process. This is due to the fact that elections bring about constant changes in majority parties within the branch of government. It cannot happen soon enough that the president is fucking history. The king of pissing on the Constitution. Some of these mental giants bring up the 14th Amendment. I don't think they've read the 14th Amendment. I will summarize it here for you. The 14th Amendment to the U.S. Constitution was ratified on July 9, 1868, during the Reconstruction era. It, along with the 13th and 15th Amendments are collectively known as the Reconstruction Amendments. However, of those three, the 14th is the most complicated and the one that has the more unforeseen effects. Its broad goal was to ensure that the Civil Rights Act passed in 1866 would remain valid, ensuring that all persons born in the United States, excluding Indians not taxed, were citizens and were to be given full and equal benefit of all laws. Quotes from the Civil Rights Act of 1866. However, it went beyond the provisions of the Civil Rights Act in many ways. Four principles were asserted in the text of the 14th Amendment. They were: state and federal citizenship for all persons regardless of race, both born or naturalized in the United States, was reaffirmed. No state would be allowed to abridge the privileges and immunities of citizens. No person was allowed to be deprived of life, liberty, or property without due process of law. No person could be denied equal protection of the laws. Over time, numerous lawsuits have arisen that have referenced the 14th Amendment. The fact that the amendment uses the word state in the Privileges and Immunities Clause along with interpretation of the Due Process Clause has meant that states, as well as federal power, is subject to the Bill of Rights. Further, the courts have interpreted the word person to include corporations. Therefore, they too are protected by due process along with being granted equal protection. Although corporations are not people when it comes to campaign contributions. While there were other clauses in the amendment, none were as significant as these. Now, I concede the 14th Amendment grants equal protection under the law. What gets them is when I ask, what law? Now, I'm on their side. This is so easy to challenge, simply because it's not a law. The Supreme Court has simply said laws making gay marriage legal are constitutional. There are no laws. This clerk hasn't violated any law because you retards haven't passed a law.